In this video, I'm going to talk about contracts and some dangerous clauses in publishing contracts that can impact your career. Welcome to the next video in the Protect Your Author Business series, where I teach you how to protect the various areas of your writing business. To get caught up with the rest of the series, click the link in the video description or the YouTube card above my head, depending on where you're watching this. Contracts. If you're a traditionally published author, you live and die by them. If you're an indie author, you may not encounter publishing contracts very often, which means that you're particularly vulnerable to bad contracts because you don't see them that often. But whether you're traditional or indie, the exposure is the same, and if you don't know what you're doing, you can end up in trouble. So in this video, I'm going to talk about common contract clauses to look out for when that next deal slides across your desk. We'll talk about publishing contracts in this video. Now, publishing contracts are quite complex, so we can't cover everything. I have experience with contracts because I've worked as a commercial insurance professional, working with contracts every day on a regular basis, both in drafting them and negotiating them. Insurance policies are some of the most complex contracts ever created, by the way, and I've dealt with many types of contracts firsthand. Insurance policies, construction contracts, releases, franchise agreements, hold harmless agreements, etc. I've negotiated with attorneys firsthand, with litigation being the result of failure. So if you're wondering about my qualification to talk about this topic, trust that I have more experience than the average author. As always, please remember that I'm not an attorney, so none of the content in this video should be taken as legal advice. For help with specifics regarding your situation, contact a licensed intellectual property attorney in your state or country. Remember, only you can make decisions for your career. The first area of contracts you want to pay attention to is the grant of rights. This is what you're granting the publisher in exchange for payment. In this section, you want to pay attention to the formats, territories, languages, and length of time that you're licensing the work. Be wary of life of copyright contracts, as it's very difficult to get out of those if you make a mistake. Life of copyright contracts are those in which you sell the publisher your work for the entire life of the copyright. In the United States, that's your life plus 70 years. Yikes. The next area to pay attention to is the do not compete clause. Essentially, this clause limits the amount of work you can produce while under contract with the publisher. So, for example, you might only be able to publish X number of books each year under the same author name. This is because publishers don't want more titles from you competing with theirs. The only way around this is to write under another pen name. In my opinion, this is an antiquated, draconian clause that can destroy an author's career by slowing their production speed. As I've talked about in previous videos, the key to success in this publishing landscape is more product. So why would you want to limit that? The next area to pay attention to is the hold harmless and indemnification clause. Basically, this is what a hold harmless and indemnification clause means. If a claim or lawsuit arises from your work, you're required to either pay or reimburse the publisher and its subsidiaries for legal fees and defense costs. Where you have to be careful is to make sure that you're not agreeing to indemnify, hold harmless, or defend anyone when there's no basis to do so. For example, anyone can bring a groundless suit for anything, right? What if you get sued for copyright infringement and it's not actually true? Should you be required to pay yours and the publisher's legal fee to prove your innocence? What you want with this type of clause is something that essentially says that you only have to hold harmless and indemnify the publisher if you're actually found to be at fault by the court. If you're really savvy, you can request to be listed on the publisher's media liability insurance policy as an additional insured. But that takes some shrewd negotiating and some know-how, and it may not be possible depending on your situation and the publisher. That's all for now because this is an extremely complex section of contract law, but be sure to do your homework as this type of clause can be very, very sneaky. And by the way, these kinds of clauses, hold harmless and indemnify clauses, are in just about every contract you sign, from publishing contracts to property leases to terms of service in the very apps you use on your phone. Not all hold harmless agreements are created equal either. Another area to watch out for is the agency clause. If you have or want to seek an agent for your work, you have to go to great lengths to make sure that this clause doesn't give them too much power. An agency clause could give them the authority to accept royalties from the publisher on your behalf and then pay you what you're owed. See any problems with that? An audit clause can help you avoid this financial mismanagement. Basically, an audit clause gives you the right to examine an agent's books. But let's be honest, if someone's embezzling from you, they're going to be pretty good at doing it, right? And most authors probably don't have the money to hire a forensic accountant if you're dealing with a particularly large agent. For the novelist, agents are no longer necessary. But for Hollywood or foreign rights deals, you may find yourself in contact with one, though these days more and more authors are signing contracts without agents. If you think you need an agent, study agency law. And I'm talking about the legal term when I refer to agency. It's critical to understand what it means and what the agent's responsibilities are, especially the fiduciary ones. The final area I want to talk about is one that you don't hear about as much, but it's something that you want to think about, and that's perversion of rights. What happens when the publisher goes out of business? What if they don't market your book as promised and you have meager sales? If any of those happen, you'd want your rights reverted back to you, right? A reversion of rights clause outlines exactly how an author can get the rights to their work back so that they can either self-publish it or shop it to another publisher. If you've signed a life of copyright contract in the grant of rights, though, good luck. However, some contracts may allow you to receive the rights to your book back if certain steps are followed. For example, a publisher might have the opportunity to take action, corrective action, if the author writes them. Maybe they'll put a new cover on the book or put it in a catalog so it can be promoted more. Or maybe the sales have to fall below a certain threshold for a certain period of time before the author can start the reversion process. Or maybe this clause is unclear and the author has to go to the brink of litigation in order to get the publisher to respond. See how wide and varying these clauses can be? You have to think about this. Don't let the money signs of the advance or the prestige of a publisher cloud your judgment. You have to consider the very real reality that you may very well want the rights to your book back at some point. This could be for any number of reasons. Yet authors can't think long term, and so they don't consider this clause. Many traditionally published writers are kicking themselves right now because of contracts they signed years ago. In the indie author space, there are some indie authors that will sign with publishers, and I predict that they're going to be kicking themselves 5 to 10 years from now because of contracts that they're signing right now. So think about rights reversions and make sure that they're as easy as possible for you. If they're not easy, this may be a deal breaker and you may want to walk away. After all, if you're going to make your career on intellectual property, you need the rights to as much of that property as possible so you can license it and make money from it. Those are just a few of the major contract areas you need to pay attention to, but not all of them. I can't go into more detail here because every contract is different, every writer's career is different, and everyone has different reasons for signing contracts. But what I'm telling you is to treat a publishing contract seriously. When you're staring a contract in the face, it's not the time to have stars in your eyes. You've got to look at it with tough, clear-eyed realism. Always have an intellectual property attorney look over your contracts to help you negotiate, even if the contract seems innocuous. Also, make sure that you're always studying copyright law. You can't learn everything overnight. Check the video description for some great resources to go deeper into the topics that I've talked about in this video. And these are all resources and topics from industry professionals. Contracts are complex and they can be downright scary sometimes. But as a professional author, you have to learn to deal with them. You have to learn the language. You have to learn to negotiate in that language. You have to learn when to walk away. That's what it means to be a professional author. It gets easier with time. But if you sign contracts without reading them, or if you don't understand the contracts you're signing, you may not have a very long career. Let that be a warning. That's it for this video. If this is your first time watching, I'd love to have you subscribe. And if this video helped you in some way, do me a favor and click the like button. Thanks for watching.